Well, we're starting to see the consequences already in some federal courts after Tuesday's election. A federal judge appointed by Donald Trump, Judge Stephen McGlynn, in striking down Illinois' assault weapon ban and high-capacity magazine weapon ban, said that assault weapons in the home are the equivalent of lifeboats on an ocean liner, airbags in a car, and storm windows on your house. And under the Second Amendment, or more particularly, under the 2022 Supreme Court decision we refer to as Bruin versus the New York Rifle Association, assault weapons, even though they didn't exist in old-timey times, since a similar ban on that kind of weaponry or any kind of weaponry didn't exist in the late 1800s and early 1900s in America, it can't be used now because only historical precedent, according to the MAGA right wing of the United States Supreme Court, all that has to exist in order for your regulation, which on its surface seems to be reasonable, for it to survive a Second Amendment challenge. And Judge McGlynn not only did that, he then decided to rub everybody's nose in it and called and said any attempt to ban assault weapons is really just being done by the, quote, ruling elite. That's code word for Democrats. So if you thought federal judges were supposed to be apolitical because they've got lifetime appointment, they're not, especially when you're like McGlynn, where you were the chairperson of the St. Clair County, Illinois Republican Party. You were involved with picking candidates that run for the Republican House and Senate in Illinois. And you are a dyed-in-the-wool member of the Republican Party and an active political one at that. Well, when you finally got your job in 2019 under Donald Trump, he didn't shed his stripes. He didn't get rid of his MAGA red approach. And it came out today because now MAGA and Trumpers are drunk with power, which is going to be their undoing come the midterms. But for now, we're going to have to bite our tongues, report on it, and talk about what to do next. But on the new ruling, the Supreme Court is going to have to now decide, because there's a Maryland case dealing with assault weapons bans. There's now this Illinois case involving assault weapons and ruling that that those bans have to be taken off the books. And there's others that are coming up from Chicago, the Northern District of Illinois. So you've got the Southern District of Illinois, where McGlynn sits, in East St. Louis, of all places, which had been the murder capital of the world, is where this judge has his chambers and courtroom. Let me repeat that. The murder capital of the world, where the murder rate is between 10 and 30 times higher than anywhere else in America, is where this judge sits. And he thinks it's an okay idea to have assault weapons and not have them banned. Now, what he was addressing was a particular law signed into law in 2023 by Governor Pritzker, J.B. Pritzker, who's often mentioned as a potential Democratic candidate for the presidency, in which they took high-capacity magazines off the streets. Anything that had 10 or more rounds in it for long guns, which is what it sounds like, 15 rounds or more for handguns, they came off the streets. High-capacity magazines are out. Certain types of armor-piercing bullets, get them off the street. And if you already had an assault weapon, it was grandfathered in, surprisingly, but you had to register it. Well, that's not good enough for Stephen McGlynn. As soon as I saw him in a 168-page decision start comparing an assault weapon to a lifeboat, storm windows, and an airbag, I knew I was in for a bumpy ride. I take a lot of this personal. I got my own opinions about the Second Amendment and the right to carry for self-protection. However, I was in Las Vegas the night of the shooting at the Harvest Festival. I was in one of the hotels, not Mandalay, but at a neighboring hotel next door. I did go into an active shooter drill at my hotel because of 68 people or more that lost their life because somebody busted a window out at the Mandalay Bay, stuck a bump stock onto a long gun, and fired thousands of rounds at other human beings. And I did interact with some of these people, both the following day when I was in court, because I was there to go to court, and on the plane ride coming home. So I have my own personal sense, having gone through those drills in my life. Now, let me read to you from the things that indicate to me, and to any normal human being, that Judge McGlynn has a bug up his ass. I don't know, that's not really a technical term, but, I get it. You were a Republican. You were a country club Republican that went MAGA, and that you ran political campaigns before you became judge. But I thought you're supposed to be a federal judge sworn to uphold the Constitution, not take pot shots at the quote-unquote liberals and elite. in the state in which you sit or anywhere else. But listen to what he said, and then I'll read you what Pritzker, the governor, said in response. Here's what the judge had to say for himself. Why do we protect ourselves with firearms? The judge posited. Okay. Now he's converted. He's conflated. We're not talking about handguns. We're talking about assault weapons, effectively weapons of war. AR-15s, AK-47s, and the like, 50 caliber handguns, weapons of war. But he went on after he made that ridiculous analogy. Too often, the perils we face are forced upon us by other people, by people who are negligent, reckless, insane, impaired, or evil. Sometimes it is the proverbial lone wolf. Sometimes it's the whole wolf pack. Truly, life comes at you quickly. And who comes to our aid in times of peril? Sometimes it's the police or first responders. Other times it's healthcare professionals. And sometimes it's family, friends, or neighbors. Sometimes it's no one. Okay. He then went on to say, what is particularly disturbing is that about the prohibition, not about his own not allowing reasonable and sensible gun regulation to go in effect. He says what's particularly disturbing about the law that Pritzker signed into law is that the prohibition of weapons that are commonly owned and used by citizens are now banned, depriving citizens of a principal means to defend themselves and their property in situations where a handgun or shotgun alone would not be the citizen's preferred arm. Now, that is now the standard. What I would like to own, what this person would like to own. I'm sure he'd like to have an anti-aircraft weapon in his backyard, right? How about a drone that's loaded to the brim with weaponry? How about that? How about a jet plane or a battleship in their port? I didn't think that was the function. Oh, everybody wants an AR-15, and by the way, the people that I know that are worried about home protection, they got two things in their house. Two things. A handgun and a shotgun. Okay? Anybody that's watching the Menendez brothers, either documentary or the whatever's going on Netflix or whatever, on Hulu, knows how much damage a shotgun can do. So if you're looking for something for home protection, I'm not here promoting it, but those are the two things you have at home. You don't have an AR-15. You don't need an AR-15. You're not being invaded, right, by this dystopic hellscape that the judge operates in and lives in. Reminds me when I was in law school, and we had a student in our class, brilliant, by the way, became a law professor, a friend of mine today, brilliant. But he would push the envelope of analysis in his debate with our law professor. We were in contracts class, which is not, kind of a dry subject. And he would throw out scenario after scenario that really were out there. And I remember one of them, he said to the professor, what if there was this is contracts class, what if there was an entire field of oxygen tanks instead of crops, and they were lined up like crops, and then X, Y, and Z happened, and something made these things explode, and the professor stopped him and said, X, you live in a bizarre fantasy world. And this judge is living in a bizarre fantasy world where he's created this dystopic hellscape. I'm like, he's been watching too many episodes of The Walking Dead, in which we're going to be besieged by, I don't know, criminals from the Congo. I mean, to continue Donald Trump's BS that we need to have AR-15s trained in our window. Come on. That's not who's breaking in. And where are the AR-15s going to be? In schools? In schools to stop school shootings? Who's going to pull it out? The 8th grader? The 4th grader? The 2nd grader? The librarian? Who's going to pull out the AR-15? We're going to have armed guards. The sheriff that sits in the school is barely enough as it is to stop that kind of shooting. So this is using a nuclear weapon to kill a fly and having AR-15s on the street. I get that people that are big Second Amendment believers say that they're fun to go shoot down at their local, gun range. I don't care. But now we have this judge who's busy in a later part of, as I said, his 168-page opinion to compare this lethality of this weaponry to a lifeboat or an airbag. I don't know. I don't know. People, I never heard an entire group of people, 10, 20, 30, 50, 80 people in a church, in a school, in a supermarket, at a parade, in a shopping mall, at a movie theater, in a church, in a temple, being killed by an airbag or a life preserver or a lifeboat. I mean, it is depraved for this federal judge to even have used those comparisons, as thoughtless as he was. He should have an entire, he should read that out loud to an entire room filled with people like the Sandy Hook elementary families, right? The people at Stoneman Douglas School in Florida, any survivor of a school shooting, a church shooting, a supermarket shooting, a shooting at a temple. Have the families or the survivors be in the room when he reads this aloud. No, they're cowards, emboldened by what happened on Tuesday for a mandate that doesn't exist. So now the Supreme Court is going to have to suck this ruling up, along with one out of Maryland, maybe one out of Illinois, put it together and say once and for all whether AR-15s, which did not exist in old-timey times, if we should be looking to historical precedents in order to decide whether to regulate them or not. I mean, even Amy Coney Barrett, who's the new swing vote on the Supreme Court, even she said, where are we going with this historical analogy stuff? There's limits. It's a weak-minded, obvious, transparent effort so that you can roll back the clock and have old-time people with their dead hand control our current modern regulation about an area that our founding fathers, our framers, and the people on the wild, wild west and the frontier could never envision. I mean, sure, there was amazing weaponry at that time, but I'll use an example, the Gatling gun. Go watch an old movie, when they had all the barrels of all the guns and the thing rotated and fired out all the bullets. That came pretty early in our, in the 1900s. I don't think any court then, the Supreme Court then, would have allowed that to be in your backyard to deal with your pesky neighbors. I don't know. I think I know what I'm doing, and then I read something by Judge McGlynn, and I have to sort of doubt myself for a minute about my analysis. We'll see what happens. We'll follow it right here on Legal AF. Now more than ever, I need your help to build this channel so that we have it as an enduring, durable, institution, independent channel devoted to law and politics. In collaboration with the Midas Touch Network and everybody over there. Help us, hit the free subscribe button. The bigger we get, the more your voice is heard. I'll be right there for it, bringing you these kind of hot takes hourly right here on this channel, on the Midas Touch Network, and on Legal AF, the podcast. Until my next contribution, I'm Michael Popok, and I am reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.